Okay, during this video, I'm going to talk about when things go a little crazy. My product comes to market, everything's going well, but a company kind of wanted to use it, and before you know it, I'm in federal court. So stay tuned. I'm going to tell you this story. Okay, things are going great with my invention, the rotating label. We're on cover of magazines. We're selling hundreds of millions of labels. We're winning awards. We won 2 Edison Awards. It's doing great. I'm collecting royalties. Life is wonderful. And sure enough, I'm getting calls from companies all around the world that wants to use my technology. And we had sub-licensed it to a company in Ireland, Kenilworth. And they got a call from a toy company, Lego, to put this label on one of their new product launches, new toy. And they had contacted me to build samples. They signed NDAs. So my office built samples for Kenilworth. We showed it to Lego. It went off, and I'm thinking, this is fantastic. I love Lego. Who doesn't? And 6 months later, well, actually months go by. I didn't hear a thing. But 6 months later, my son is having a birthday party, and he loves Lego. Who doesn't? He's loving it. But my wife comes out. I'm in the garage. And my wife comes out and says, Steve, I've got something to show you. I'm like, what is it? She says, their product, Bionicles, has your rotating label on it. And I was like, my heart just fell out. I mean, I couldn't believe it because I didn't hear anything back from Lego. I didn't hear anything back from the company that we had sub-licensed it to. So what really bothered me too was, even though we made samples, something went wrong. But this became a worldwide hit. It was selling everywhere. And everywhere I went, I saw it. I saw it on TV. I saw it at store shelves. I couldn't stop seeing this product with my technology on it. Okay, so what did I do? Well, at first, I did what anybody would do. I'm like, wait a minute. I have to go sue them. That was the first thought, of course. So I called my patent attorneys, I showed them what was going on, and they said, Steve, we could probably send letters out there to kind of fix this situation before we get a little nasty here. Why don't we just see if we can work this thing out? Well, long story short, it didn't work out that way. Most litigation cases seem to kind of work, they kind of settle before you ever get to court. Well, this didn't happen this way. It got a little bit tough at times. I have to tell you, I remember, there were some times I didn't want to go to the meetings. It was really ugly. It went on for 3 years. We did settle 2 weeks before it went to trial. Okay, but still 3 years. My attorneys were fantastic. They took it on a contingency, but there's a lot of out-of-pocket expenses. Long story short, it's just painful. Now, what did I learn through this whole process? Well, it's interesting. I do believe, I had a couple patents that were issued, and we had more that were going to be issued. But you have to realize Lego didn't do anything wrong. And a lot of people are like, wait a minute, they didn't do anything wrong. No, they didn't like the price that my sub-licensee was showing them to sell the label to them, so they came up with another way to put a rotating label on it. Because I own the manufacturing techniques, as you see back here, but not really a true rotating label because it was done, 80 years ago or something like that. They found a workaround, and that's okay. That's fine. They found a workaround. And they thought because of this workaround, they weren't violating my intellectual property. That was their perspective. Okay, well, what they didn't realize, and what I'm going to be teaching you, is how to write intellectual property that can kind of stop the workarounds, or at least make it an argument. There you go. I'm a firm believer that when you're filing intellectual property, you have to look in the future and protect not only your invention, but the innovation, and you have to be really smart about it. And sure enough, we were, and there was an argument, and we settled 2 weeks before it went to trial. So what did I learn through this whole process? I learned a couple things. Number one, patents are just words. And they're going to be interpreted differently by a judge, a jury, a licensee, whoever, and it's a slippery slope. But if you know kind of what's out ahead and you're thinking a little differently, not just from a legal perspective, but from a business perspective, which I'm going to show you on this channel, you're able to write your patent applications in such a way it overcomes future arguments. There you go, future arguments. And I'm going to show you how to do that. So what did I learn? It was a great experience. Yes, it was painful. Yes, would I do it again? I'm not even sure I'd do it again. The reason why I didn't realize at the end of the day, was it really hurting my business? Did it hurt my ego? Yeah. Did it hurt my business? I don't know, because the technology they were using, the technology they were working around, it wasn't right for my customers that wanted high-speed applications. This was running fairly slow. So the whole process taught me a lot about intellectual property. It taught me how to write patents that have value. It taught me how to write them in such a way that overcomes arguments. It taught me to write them in such a way that people want to license those patents from you. And I'm going to show you how to do it through this channel. So this is Stephen Key. Thank you for watching. Yes, it was hard. Yes, I felt violated. Yes, yes, yes. But at the end of the day, I learned a great deal, and I'm going to pass that information off to you. So thank you for watching. This is Stephen Key. Until next time. If you have any more questions, do not hesitate to reach out to me, Stephen@patentyourinventions.com. And here's my channel up here. And if you want to watch more videos, please click here.